Hi everyone, good morning, good afternoon, good evening, whatever you are. My name is Andre Luis Monteiro, or Andre if you prefer, and I'm off counsel at Quinn Emanuel London office. This is probably nothing new for my Brazilian colleagues and friends who are watching the event, but I know we have some non-Brazilian practitioners in the audience as well. And always good and polite to introduce yourself if you are the presenter. Anyway, this event is part of the São Paulo Arbitration Week, a great initiative led by CAM-CCBC, which is one of the most important arbitral institutions in Brazil and also in Latin America. This event also represents the importance of Brazil for our practice. David and I have been working on a couple of cases together representing Brazilian clients in arbitrations and court proceedings in the US. I'm also working on other matters in London for Brazilian clients as well, both arbitration and court proceedings. The London and Paris offices worked together on a case that won the 2021 Latin Lawyer Awards Deal of the Year in arbitration in the energy sector. And the Paris office is currently working on another arbitration for another Brazilian client. These are just a few examples of cases that show the importance of the country for our practice. We, of course, hope to continue developing our practice in Brazil and have lots of opportunities to visit São Paulo, Rio, everywhere. Our plan today is to discuss some important remedies available in international arbitration, which can be very, very helpful in creating and developing a successful strategy for your case. We will discuss security for costs, anti-suit injunction, worldwide freezing order, and enforcement of these decisions. To help me with these topics, I'm lucky to have here today an outstanding and truly international set of practitioners based in Brazil, the US, the UK, and France. David and Debora will discuss security for costs. David is a partner of Quinn Emanuel in the US and also the head of the International Arbitration Group in the US and Latin America. Debora is an independent arbitrator at Visconte Advogados. And then Voisin and Valeria Galíndez will talk to the anti-suit injunction. Thomas is our managing partner at the Paris office, and Valeria is an independent arbitrator at Galíndez Arbitration. After this, Anthony Sinclair will explain a fascinating remedy called global freezing order or worldwide freezing order, mostly known in the UK, in Singapore, and other common law countries. Anthony is a partner in our London office. Last but not least, Fabiane Verçosa will give us an overview on the recognition and enforcement of these decisions in Brazil. Fabiane is an independent arbitrator and counsel at Verçosa Advocacia. Members of the audience, please don't be shy. Send your questions during the presentations or at the end, and I will put these questions to the speakers. There is no such a thing as a silly question or simple question, so we will welcome all of the questions. Just send it right over. Okay, so the introduction is made. Let's start properly. I think David and Debora, over to you. You are going to start, right?
Yes. Thank you very much, Andre, for the introduction and invitation. It is a pleasure to speak in this Quinn Emanuel talks, arbitration talks, with such distinct colleagues. And such an interesting topic as well, such as security for costs. And in order to address this topic, David and I have divided in 5 main issues which we intend to do in 30 minutes. And we will both dealing with them in this first part of our panel. As you all know, security for costs is an interim measure that, like others, has the purpose of mitigating the effect of the lapse of time between the occurrence of the loss or damage and recovery or full compensation. It's also intended to protect the party's interests until an award is rendered and becomes susceptible of enforcement. And last, to prevent the aggravation of a dispute or further injury to the party seeking orders as to interim measures. And these interim measures include, as you all know as well, those that have to do with discovery, preservation and production of evidence, those that have to do with preserving the subject matter of the dispute, those that are destined to permit the effective execution of the award. There are several soft laws that address this issue, but I find particularly useful and important the ones of CARB guidelines. CARB has a guideline on provisional interim relief and another one on security for costs that I will be addressing in this speech because I think they're very useful and very accurate on these issues. And the one on the interim relief says that addresses specifically security for costs as an interim measure and says that in international arbitration, where the costs may be considerable, a party may be entitled to a level of cost protection from frivolous claims or claims brought by insolvent parties. And then security for costs then is a type of interim measure which requires the claiming party to provide security for whole or part of the party's anticipated costs, where there is a risk that they will be unable to pay the costs if their claim fails. And arbitrators, when faced with an application for interim measures, to establish where they have both the jurisdiction to hear the dispute and the power to order interim measures. As I have discussed with David on this topic yesterday, the point on jurisdiction has been already established that the arbitrators can award interim measures in most parts of the world, and also that these interim measures cover security for costs, even in our arbitration rules or arbitration laws that treat this topic broadly. So traditionally, security for costs it's an English remedy that is derived from the fact that the English courts routinely made order for costs in favor of the prevailing party. It was not at the beginning a tradition in all courts, even though in Brazil we find we find a word on costs also in litigation with some specifics that we have dealt before in relation to the honorários de sucumbência. So also, as you all know, and this is all an introduction to our topic, so we don't address things directly, when asked to make award for costs at the end of the proceedings, an arbitral tribunal has to address a number of issues. First, the tribunal must decide whether it can and should reallocate costs and on what basis. Example, costs follow the event. Second, if it decides to make a cost award against the unsuccessful party, the tribunal must determine which of the prevailing party costs are recoverable from the other side, including the type and amount of recoverable costs. If the tribunal's costs are covered, institution costs, parties' legal fees, and other costs. Third, the tribunal must determine which and how much of the costs should be awarded against the successful party in the circumstances. And as I mentioned, in Brazil, we can also find a discussion if the tribunal has the power to award contractual legal fees and our honorários de sucumbência. And in what cases, of course, if the parties have not agreed on this in the arbitration agreement or in the terms of reference. So based on the, I think it's a more or less global principle that costs should follow the event. This is the rule that the tribunal should follow when awarding costs. Unless it shows that the tribunal that it's not appropriate in relation to the case, if it understands that the party's behavior should be addressed and should mitigate this principle. Before I pass the word to David, I will address the UNCITRAL rules, which are specific on the award on cost, that provides for this on Article 40 and Article 42, that says that the costs of the arbitration shall in principle be borne by the unsuccessful party or parties. So with this introduction on award of costs and on security for costs as an interim measure, I pass the word to David that will address this in this question in the US perspective.
Thank you, Deborah. And Andre, thank you for that very kind introduction to our panel. So as Deborah mentioned, what we're going to be addressing this morning is the topic of security for costs and trying to provide a comparison between sort of the U.S. perspective on this issue, how U.S. courts have dealt with this issue in the context of arbitrations, both commercial, domestic arbitrations and international arbitrations, and how Brazil deals with this. Deborah mentioned the concept of costs following the event, and that being generally a universal principle. And that is generally true, except in the United States. In the United States, the so-called American rule applies to the question of costs in regular U.S. proceedings and in regular, for example, U.S. domestic arbitration proceedings. And the American rule basically provides that each party will bear their own costs. So it's very different than the rule that's that is applied normally outside of the U.S. and in most parts of the world, where the loser pays the winning side's costs. But in the arbitration context, it's a little different, and this is interesting and important. In the arbitration context in the United States, most courts will respect a decision by a tribunal to award costs to the winning party. One of the first topics that we want to talk about here is what kinds of costs are we talking about? Because by way of example, in U.S. litigation, in various stages of the U.S. litigation, there may be the statutory provisions that allow one to recover costs, but usually those are limited to the costs, the hard costs associated with the proceedings, such as copy costs, filing fees with the court, etc. But they generally exclude attorney's fees. But in the context of arbitrations, the U.S. courts will generally defer to the arbitration institution or the arbitrators' decisions on this issue, or obviously to an agreement by the parties with respect to this issue, if that's built into the arbitration agreement. And therefore, the sorts of costs that are include fees and expenses of arbitrators, the costs of the arbitral institution, other costs associated with the proceeding, and importantly, the largest component of costs, which is the attorney's fees. So in the U.S., this concept of costs includes the entire umbrella of costs that are associated with advancing an arbitration proceeding, be it a domestic or an international one. Obviously, the easiest way to ensure that you will get costs is to build that into your arbitral agreement. But even in the absence of having that in your arbitration agreement, most arbitral rules, there are rules of arbitration for institutions, provide either, if they don't provide it explicitly, provide the implied authority for arbitrators to issue costs in favor of the winning party. So on the issue of security for costs, the question then becomes, when can one obtain security for costs? And if one is faced with such an application, how does one oppose the application? I'll provide some brief anecdotes from the U.S. perspective, and then pass it back to Debora to provide some anecdotes from the Brazilian perspective. Generally speaking, as Debora mentioned, the issue or the question of whether a tribunal has jurisdiction to order security for costs, that is, an interim decision, an interim award by the tribunal requiring one party to post some form of security, generally speaking, some either a fixed dollar amount or some assets or something, to ensure that there will be basically a pot of money at the end of the proceeding to satisfy an award of costs, or potentially to satisfy the entire award or some portion of it. U.S. courts have generally, notwithstanding what I said about the American rule, U.S. courts have generally accepted that arbitral institutions and tribunals have the authority to order such a security. And generally speaking, when one looks at the U.S. courts and analyzes some of the cases that have dealt with this, and there aren't that many, quite frankly, but there are some, what one finds is that the courts defer to arbitral tribunals, and that is in ordering such costs, and that is something that is built right into the Federal Arbitration Act in the U.S., which basically grants a lot of deference to arbitral institutions and arbitral tribunals in carrying out arbitral proceedings. There are some cases that report on this issue, and the cases where one has seen courts upholding a tribunal's decision to order security for costs generally are ones in which there is a very clear picture and evidence presented that one of the parties is insolvent or is doing something to make itself judgment proof. And so, by way of example, there are cases, Seadrill versus BP Exploration is one case in which a court in the Southern District of Texas upheld an arbitral tribunal's decision to order security for costs against a party who had filed for bankruptcy. And the rationale was, in essence, if you're filing for bankruptcy, you're saying, as a matter of law, you're insolvent. And so the other side then has a legitimate reason and basis to be concerned about whether you will be able to honor a cost award. And in that circumstance, that court upheld the security for costs order that was given by the tribunal. I'll mention briefly, Debora mentioned the intertrial rules, and she mentioned articles, I think Article 42. Also, Article 26(2)(c) is interesting because it is of all of the arbitral institutions rules, it is one of the arbitral institutions, but arbitral rules that govern proceedings. 26(2)(c) expressly provides that an arbitral tribunal may order interim measures to preserve assets out of which a subsequent award may be satisfied. So it speaks directly to this issue of security for costs. And again, very briefly, before turning it back to Debora, on the issue of factors, I talked about insolvency. That is one factor that arbitral tribunals seated in the U.S. will look at when determining whether to order security for costs. And the other is, I would say, some form of misconduct by one of the parties. And by that, I mean specifically some action or actions taken by one of the parties to divest itself of assets that would be available for satisfying an award or an order of costs at the end of the proceeding. If one can develop evidence like that, which obviously is not very easy to do, then you're very likely to find tribunals amenable to ordering security for costs. Having said all of that, I should note that that obtaining an order of security for costs is an incredibly high standard. It is very difficult to do, and those of us who have faced such applications and/or made such applications in arbitral proceedings will appreciate how difficult it is to get such an award, and that has a lot to do with the fact that you're basically asking an arbitral institution to require one side to post some form of security in order to satisfy a potential award for costs in a case where the merits still haven't been determined. So beyond misconduct or insolvency, you also have to show a likelihood of success on the merits. And if you can sort of put all that together in a compelling package, you have a chance at getting such an award. With that, I'll turn it back to Debora to assess from the Brazilian perspective what are the factors that play into an order for security for costs in Brazil.
Thank you, David. I just realized that if we speak on all the topics that we have planned, we'll cover the whole entire time of the panel. So in benefit of time and for all our friend speakers, I will briefly address some of the issues, including the one you mentioned. I haven't found any factor that distinguishes the Brazilian application of security for costs from other jurisdictions. But there is an issue that I will touch upon that I believe that you have not addressed, is that the fact that in most tribunals also assess if there was a material change in the circumstance since the conclusion of the arbitration agreement. So if the party already, for example, if the party did not have assets if was in a if the party was located in Panama, for example, as an example that I had in ICC Academy, you cannot allege at the end that it's in a haven, in a paraíso fiscal, and doesn't have assets because of this. So you knew it from the start that the party did not have assets. So it had the material circumstances, the financial circumstances of the claimant have to have changed in order for you to obtain the security on costs. Also, in this, you have mentioned that in exit cases, the threshold is higher, and they have normally dismissed application for security on costs on the past. And in doing so, the tribunals have relied on a range of different arguments, such as the following: impropriety of prejudging the claimant's case on the merits. And this I've seen also in commercial cases, that a tribunal is reluctant to assess if the party has merits on the case. And also failure of the part of the respondent to establish a concrete risk of non-payment. Also, that there's nothing unusual in the fact that claimant's a vehicle and has no asset, and this does not justify a security for costs award. A security for costs cannot limit claimant's access to justice, and the rejection of security for costs application does not pose a threat to the integrity of the proceedings. And in a case, Guaraki America vs. Iraqi America, and Relec versus Bolivia, the tribunal refused to order security for costs, given the fact that the controversy generated in the wake of RSM Production Corporation, and this is worth also citing a little bit of the decision of the tribunal, that the investment treaty tribunals have the power to grant provisional measures, and the order of security for costs is a very rare and exceptional measure. The respondent has not been able to supply evidence to justify the extraordinary measure that it requests. As a factual matter, the respondent has not shown a sufficient causal link such that the tribunal can infer from the mere existence of a third-party funding that the claimants will not be able to pay an eventual award of costs. And this issue of third-party funding is a very important one in security for costs, and it's also been addressed by an ICA report on third-party funding that has a chapter on security for costs. The mere existence of a third-party funding is not also sufficient for an order for security for costs to be granted. There has to be a test to assess if this proves that there's a lack of chance that the claimant will pay costs at the end. The terms of a funding agreement may be relevant to establish that the claimant or content claimant can meet any adversary costs, including in particular the funder's termination rights. In the event that security turns out to have been necessary, the tribunal may order the party to demonstrate, to disclose the funding agreement and for posting such a security. So in conclusion, the mere recourse to a third-party funding is not generally considered to carry out an element of bad faith or abuse, which is required, especially by investment tribunals towards security for costs. Also, as we mentioned yesterday, a proof that claimants will not pay costs is the fact that in past cases, claimants did not comply with the award. So this was also addressed as an issue of bad faith, and the merely fact that the party who has a third-party funder was never used as a ground for the granting of security for costs. Also, and last, we had thought about addressing the enforceability of these awards. And since this topic is Fabiana's topic, I'll just say a few words on it. That the awards are enforceable in Brazil if domestic and awards from tribunals seated outside of Brazil. That domestic awards can be enforced by the arbitral letters, and international interim measures can be enforced by a rogatory letter, which is not very could not be very useful if you want to enforce an interim measures. And there are some commentators that already admit the enforcement of these interim measures by the arbitral letter. I am sure that Fabiane will address this later on, so I leave it here and pass the word to David.
Thank you, Deborah. Just in the couple of minutes that we have left, I'll touch on two issues that build on what Deborah was talking about. First, I'll start where she ended, which is the question of whether in U.S. courts an order or an award of security for costs is enforceable as a during the conduct of the arbitration proceeding, whether such an award or order is one that one can enforce in the courts. And the answer, generally speaking, is yes. Obviously, it'll be very dependent on the wording of the arbitral tribunal's order/decision on this issue. But generally speaking, under the Federal Arbitration Act, where a tribunal has disposed of an issue, a distinct issue within the case, and its decision is sufficiently final, such as an order for security for costs, that decision can then be taken to the U.S. courts, and confirmation of that decision can be sought, and that arbitral tribunal's decision/award can then be confirmed and converted into an executable judgment. I'll cite one example of such a scenario that happened in U.S. courts: the Banco de Seguros del Estado versus Mutual Marine case, which is at 344 F. 3rd 255. It's a decision by the Second Circuit, which is the court of appeal that sits and hears appeals from federal cases in New York and in other jurisdictions. And in that case, the Second Circuit upheld a decision by the Southern District of New York, which confirmed an order for security for costs that had been granted in favor of one party. And in that case, the security that had been ordered was the issuance of a letter of credit. And in essence, the party who had obtained that order was able to get a judgment, and in that way compel, through the court's power of sanctions, the counterparty to post that letter of credit. So it can be a very obviously a very important and powerful tool, but overlaid over all that is what Debora and I have both said, which is it's an incredibly high burden and high standard to obtain in order for security for cost. The last point that I'll address that Debora also touched on, which is the question of how this issue plays out when you have third-party funding. And I'll just make some brief remarks on that. Firstly, I think it's those of us who participate in investment treaty arbitrations, and also in commercial arbitrations, but I think one is seeing this more so played out in investment treaty arbitrations. This question of security for costs is now generally being utilized by some parties as a tactical tool/weapon to try to one, compel disclosure of whether third-party funding agreements are in place. And I think while this is still a very evolving area of the law, we are seeing more and more tendencies of tribunals in investment arbitrations of requiring parties at least to disclose whether they have third-party funding arrangements. That will then lead invariably to a discussion and disputes over whether the third-party funding agreement needs to be disclosed, and the tribunals are mixed there. I think that we could have a whole separate topic on that, but invariably then that leads to a question about whether, if a claimant is seeking third-party funding for advancing claims against a sovereign, whether that then means that they should be required to post security for costs, and that's an incredibly interesting topic. I think many tribunals, when faced with that question, do balance the requests usually made there by respondents with the very important counterbalancing interest of the claimant's right to have access to justice. And I think by and large, again, generally speaking, one can say that up until now, efforts by respondent states to require claimants to post security for costs because they are funding their case through some third party have not been very successful. With that, I think we're done with our 30 minutes. So Andre, we will pass it back to you. There are many other interesting things that we could talk about with respect to this topic, but I think at least Debora and I have scratched the surface and hopefully piqued the interest of the audience. Thank you.
Thank you, Debora and David. Definitely, it was a very comprehensive overview about security for costs. And I was, while we were speaking, I was remembering I'm working on another case in arbitration in Africa, not related to Brazil, with the Paris office. And we had a really hard, tough discussion about security for costs recently, when you spent like 3 months discussing security for costs. But at the end, we prevailed. Okay, so let's move on to the next topic, anti-suit injunction, with Thomas and Valeria. Please, the floor is yours.
Thank you, Andre. Thank you. It's a pleasure to be here with you today. Sorry it can't be in person because it's rather disturbing to see oneself talk in front of you. But anyway, we'll move forward. So anti-suit injunction, or more precisely, anti-arbitration injunction, is when a domestic court orders to discontinue arbitration proceedings. And it can occur in a number of circumstances, and generally those circumstances are that the arbitration proceedings are based on an arbitration agreement that's inexistent or null and void. It could also be because the arbitration agreement is inoperative, or that it binds a party, or the party to the arbitration is not bound by the agreement itself. It could also take place in circumstances where there are competing proceedings and where the issue is res judicata. So there's many instances in which it could take place, in which a domestic could order an anti-arbitration injunction. And the object of the order is to circumvent the arbitration proceedings. So basically, it will cut the arbitration process. The arbitral tribunal will not decide its jurisdiction or whether the issue is res judicata, and this will be to the benefit of a domestic court or another arbitral tribunal. And in that case, you can see the benefit for a party because it could be a gain of time and of money that is quite substantial. But that is if you get it right, because it's not because a domestic court grants an anti-arbitration injunction that it will be followed by the arbitral tribunal. And this is something that we will touch on with Valeria after our presentation, because it's efficient if everybody respects the anti-arbitration injunction. If it doesn't, it creates a mess, and it probably complicates matters and will render the proceedings more expensive and probably more lengthy. So this, is a nutshell, is what it is. And if what the issue boils down to is really who should decide those issues and when should they be decided, and more precisely is who is the best place to decide them. And just by formulating those questions, we see that the issue of anti-arbitration injunction is very close and is intertwined with the concept of competence-competence. And basically, where a country has a very liberal or favorable arbitration proceedings and have a very strict application of the principle of competence-competence, there will be very little place for anti-suit injunction. And to the contrary, if ever a country authorizes its court to intervene to a greater extent in arbitral proceedings, anti-suit injunction will generally have a broader place. And I will be talking more specifically about the French and the English perspective, and those are two jurisdictions which have very different views, or at least apparently have very different views on how to on anti-suit injunction and if they can. If we start with the French, and it could be a very short presentation because, in short, there's a decision from the French Supreme Court that says that French court cannot order an anti-arbitration agreement, and it's a principle that is very broad and suffers apparently no exception. But if I just stop there, I wouldn't really make credit to the complexity of French law and probably it would be a little too short, because the concept of anti-suit injunction is not alien to French law and French courts. And the French Cour de Cassation has actually recognized in one single case, but one case is enough, that French court could order an anti-suit injunction. And that case was a very specific topic relating to bankruptcy. And it was a creditor in a bankruptcy that was launched in France that tried to enforce or to seize assets of the bankrupt party abroad. And the French court issued an anti-suit injunction. And in that case, the French Supreme Court recognized that it was authorized to do so. So the door is not completely closed in the matter of anti-suit injunction. And I would even go further, because in 2009, the French Supreme Court recognized that a decision rendered abroad, an anti-suit injunction rendered by a foreign jurisdiction, was not contrary to French international public policy, which means in practice that an anti-suit injunction could be recognized, if it doesn't come from a European Union court, could be recognized in France. So this has nothing to do with arbitration and anti-arbitration injunction. However, it does show that French legal order, French court, and French law is not completely closed to the concept of an anti-suit injunction. So what is the position regarding arbitration? Well, here the matter is slightly different, because the French Supreme Court, after those two decisions, rendered a decision saying very clearly that if ever you had to deal with an international arbitration, French court could not intervene whatsoever, because it was part of an autonomous legal order. And this is the backbone of the French legislation on arbitration, which is that arbitration does not belong at all to the French legal order. It is an autonomous order, and the only link with the French legal order is to help constitute or to support arbitration in the constitution of the arbitral tribunal. And when I say that it suffers no exception, is that as soon as the arbitral tribunal is constituted, you will find no French court that will issue an order whatsoever. And this is the position of the French Supreme Court. It is also the view of most legal authors, including the late Professor Gaillard. Now, if we go back to what I was saying earlier, and the fact that it's very linked to the principle of competence-competence, well, as you may know, French courts and French law has a very restrictive approach to competence-competence, in that as soon as the arbitral tribunal is constituted, French courts will have to decline jurisdiction. And the only exception is before the arbitral tribunal is constituted, if ever the arbitration agreement is considered to be manifestly void and null or inapplicable. So the threshold is very high. And so basically, you will very unlikely get an anti-suit injunction in France. The only exception is if ever a French court considered, and this is my personal belief, is if ever a French court considered that an arbitration agreement was manifestly inexistent and decided that it could try the case before the arbitral tribunal was constituted. In that case, if the parties decided to constitute a tribunal and the tribunal agreed to carry on with an arbitration, I think there may be room for a French court to issue an anti-arbitration injunction. This has never occurred, so this is wishful thinking, but it seems to be a possible scenario, which is very unlikely to happen in practice. If we turn now to the English perspective, well, here it's very different. And the English courts and English law have a very different approach and a more pragmatic approach, because it's undisputed, or it's very well known, that English courts consider that they have the power to issue an anti-arbitration injunction. They also consider that that power is broad, in the sense that it issues an anti-arbitration injunction if the seat is in England, but also in some instances where the seat was not in England, or those instances are rarer, but I mean, they do exist. And also there needs to be a link with England, but that link can be rather very limited depending on the circumstances. So it's either because English court would consider themselves competent or English law. There must be some link, but it's difficult to understand exactly what that link should be. Now, if we go to the conditions that English court will take into account for granting an anti-arbitration injunction, well, there's mainly two. The first one is if ever a legal or equitable right would be infringed, or if ever there was a threat that a legal or equitable right of a party would be infringed. And the second condition, and they're not cumulative, is that the continuation of the arbitration would be vexatious, oppressive, or unconscionable. There are other criteria set out sometimes in case law, such as unusual circumstances, but just reading those cases and those criteria, they are extremely vague. And so we'll see what courts actually do in practice to give us a little bit of enlightenment of what is the situation in England. Now, to be complete, there are two guiding principles that English court will apply. The first one is that there should be, or English court should refrain from interfering into an arbitration proceedings. This is a principle set out in the Arbitration Act. English courts were not originally known for not intervening and were rather, on the contrary, known for having a rather intrusive aspect. This is not the case anymore, and this is one of the leading principles. The other principle is that a court will unlikely grant an anti-arbitration injunction in the event that a party has participated in that arbitration. So the more a party participate, the less likely you would be able to obtain an anti-arbitration injunction. So in what cases have English court granted those measures? Well, it has been to avoid an arbitration where the arbitration agreement was inexistent. There was also a case where the party was not bound by the arbitration agreement. There are also several examples of injunctions being granted to avoid the issue to be tried twice, where the issue was res judicata. But those three examples that I've given, where the measure was granted, there are very similar cases where the measure was not granted. And I'm English, at least in part. I'm not a common lawyer. I have no common law education. But reading those cases, I fail to see the difference in between when a court will grant or when it won't. And it's basically, there's a very broad discretion on English courts. But looking at it, what is clear is that the principle that English court did not interfere in an arbitration is not exact. They do. They do in very limited circumstances, but they do. And the exact criteria is unclear. Well, on that note, and just to finish on this, the likelihood of obtaining an anti-arbitration injunction is limited. There are not that many cases in England, but there are some. And they are much more important than in France. And just to conclude on this, it's actually, if we do again the parallel with competence-competence, the Arbitration Act does allow court to intervene ahead of the arbitral tribunal on certain circumstances. And so there's a real parallel between the power to grant anti-arbitration injunctions in England and in France, and the principle of competence-competence in those two countries. And on that note, I will pass the floor to Valeria to see the arbitral tribunal's perspective.
Thank you, Thomas. And well, first, thank you, Andre and Quinn Emanuel for the invitation. I have the duty to address the issue from the arbitrator's perspective, and I think I'm gonna deal with the topic backwards, meaning that I'm going to first answer the question and then explain how I came to that conclusion. So the topic that was put by Andre was whether or not arbitrators have power to issue anti-suit injunctions? And the short answer is yes, in general, obviously, but the short answer is yes. Arbitrators do have power to grant such kind of remedy. This is confirmed by case law in investment arbitration and commercial arbitration. And I think that although there are some discussions in certain legal authors regarding the sources of those powers or the appropriateness of this remedy, I think the consensus is that arbitrators do have those powers. But let's see how we can come to that conclusion. What are the bases for that conclusion? And basically, they are three: the arbitration agreement, the law governing the arbitration agreement, and the law of the place of arbitration, and the rules of, actually four, the rules that were provided by the parties to govern the proceedings. And we have two approaches, basically, with regard to those sources. The first one, and the more liberal one, is the French approach that was basically, I think, led by late Emmanuel Gaillard. He's, I think, the representative of this line of thought that says that the source of the power, the arbitrator's power to grant anti-suit injunctions is the arbitration agreement. And in particular, the effects produced by the arbitration agreement, the competence-competence that was mentioned by Thomas, and also in the previous panel by Debora and David, would be the root for that understanding. Is the fundamental principle of arbitration that arbitrators have power to rule on their own jurisdiction. So logically, that means that they are entitled to examine any challenge to their jurisdiction based on the alleged ineffectiveness of the disputed contract, which means that they can decide any challenge to the arbitration agreement itself, understanding that a challenge to the arbitration agreement would be commencing court proceedings in parallel to the arbitration. But a further principle that may justify this understanding is that the arbitrators must render an award that is capable of being recognized and enforced. Now, on the other hand, we have what I would say a more formal approach that understands the source of the powers actually cannot be any of those two principles that I've mentioned, but basically what is provided under most of national laws, which is the power to grant injunctions, urgent measures. And that we can see, as I've mentioned, in most of national legislations and institutional rules. The working group of the United Nations Commissions on International Trade Law followed this approach expressly when they clarified that Article 17 of the model law, which regulates interim measures, covers anti-suit injunctions. And in particular, Article 17.2 of the model law defines interim measures as any temporary measure, whether in the form of an award or in another form, by which at any time prior to the issuance of an award by which the dispute is finally decided, the arbitral tribunal orders a party, inter alia, to take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself. So according to the working group, the words prejudice to the arbitral process itself were added to the article in 26 to clarify that an arbitral tribunal had the power to prevent obstruction or delay of the arbitral process, including by issuing anti-suit injunctions. We know that there are no national legislations that make express reference to anti-suit injunctions, But it is true that in most of those legislations, it is clear that the arbitrators have power to order this kind of relief. And in procedural rules, such as in the ICC, the LCIA, and the Brazilian arbitration institutions, they basically have the same kind of provision that allow arbitrators to grant interim measures. The Brazilian Arbitration Act, as many of you know, in Article 22, it's a little bit more, I would say, avant-garde, in the sense that it provides that the arbitrators may even ask the courts to assist them on imposing a compliance with respect to orders that were rendered by the arbitral tribunal. This is Article 22C, that could be even interpreted in a more, I would say, flexible way in order to try to include the powers of the arbitrators, for instance, to even order to a court to refrain from instance to continue with a certain proceeding. Now, what will be the requirements for granting arbitral anti-suit injunctions? The requirements were mentioned by Thomas with respect to English courts, but arbitrators, they tend to follow the same requirements, and those are basically the same of the requirements that are established for granting interim measures. Harm not adequately reparable by damages, and what in civil law countries we call the fumus bonus iuris, or the reasonable possibility that the requesting party will succeed. But in the case of anti-suit injunctions, I dare to say that we would also have another two requirements. The first one, the prima facie jurisdiction, meaning that the arbitral tribunal has to at least have a clear understanding that the dispute that is submitted to arbitration can be excluded of the state court jurisdiction. The test is actually the contrary that the one that is made by state courts. Thomas has mentioned that the arbitration agreement in the case of anti-arbitration injunctions, and the test is made by French courts, should be the one that in France they say qui crève les yeux, meaning that is manifestly void or null. And with respect to arbitrators, the test is I would say reverse, in the sense that it's an interpretation that is a little bit more broader than the one that is made by courts, in order to assess whether or not there is a valid arbitration agreement. The other requirement would be the breach of the arbitration agreement. And this is so because it's not always, I would say, clear that the court proceedings, the parallel court proceedings, are really in breach of the arbitration agreement. There is no uniform solution in arbitration case law regarding the elements that are analyzed by arbitrators in identifying what proceedings could constitute the breach. We will have two approaches: full identity of the parties and cause of action, and a more liberal approach which will focus in the heart of the dispute rather on the formal identity. But again, this is still being, it's not consolidated in arbitration case law. And then we would also have something that I think we'll touch in more detail in after Thomas intervenes again, which is the appropriateness of the anti-suit injunction. Arbitrators should question that as well before ordering any kind of remedy in aiming at suspending or asking a party to refrain to continue a certain court proceeding or some court proceedings that are in parallel. The appropriateness can be assessed by asking whether or not there is an evident risk of conflicting decisions. It seems obvious, but in any case, it may be delicate depending on which kind of court proceedings we are dealing with, and also how national judicial systems work. This is something that many arbitrators sometimes ask the parties to explain, how those systems works and which will be the time frame for each of the court proceedings that are being considered as being in breach of the arbitration agreement. And the other question that the arbitrators may ask themselves before issuing an anti-suit injunction is if the party has acted abusively, meaning if the court proceedings are indeed frivolous or part of a tactics to obstruct the arbitration proceedings, or whether or not the party somehow has a legitimate understanding that there is no arbitration agreement or there is no valid arbitration agreement. And finally, the question of whether or not the anti-suit injunction has a practical value, and it will depend a lot on the enforceability of that order, which is the topic that we will address later. Just as an example of how anti-suit injunctions may not be effective, I think that it's worth mentioning a case that, at least for the Brazilian community, is very well known, which is the case involving the telecom company Oi. In 2016, as many of you know, they have initiated a Chapter 11 proceedings before Brazilian courts, but there was also arbitration proceedings before the Stock Exchange of São Paulo Arbitration Institution. And we finally had conflicting decisions coming from the judge that was in charge of the Chapter 11 proceedings, the sole arbitrator that was conducting the arbitral proceedings between shareholders of that company, and later a third court proceedings, which has been largely used and unfortunately used here in Brazil, which is the conflito de competência, in order to assess which is the authority that has actually powers to decide, or jurisdiction, to decide the dispute on the merits. So I think this is a case in which we can see that, in spite of the anti-suit injunction that was ordered by the sole arbitrator, basically the party that had no interest in continuing with the arbitration decided not only to ask first a court order coming from the bankruptcy judge that would continue analyzing the same issue that was being submitted to the arbitration, but also, as I've mentioned, a second court proceedings aiming at annulling completely the jurisdiction of the arbitral tribunal, which means that anti-suit injunctions, and as the same way as Tamar mentioned in the beginning of his presentation, they can be both very beneficial to the arbitration proceedings, but at the same time, they can aggravate the dispute and even put in risk the recognition and enforcement of a future final award. So before submitting that to an arbitrator or to an arbitral tribunal, parties should consider the side effects that this kind of remedy may have on the arbitration itself. So with that, I pass to Tomás for him to now to address the practical, I would say, the practical view of the anti-arbitration injunctions.
Thank you. Just to bounce back on your last comment, Valeria, I think this is specifically why courts, domestic courts and arbitral tribunal are very reluctant to issue anti-arbitration or anti-suit injunction, because assuming that you are successful, and that you have this anti-arbitration injunction or the anti-suit injunction from the arbitral tribunal, is what do you do with it? And here it's an extremely complex question, because in international proceedings, you'll have probably several legal orders that are involved, plus the arbitral tribunal, and none of them really have authority or determinative authority on the other. And so I think the way to assess these practical consequences of what you do with your anti-suit injunction, and there's the arbitral tribunal's perspective and there's the parties' perspective, I think that the interesting or the focal point should be, what do you risk? And here it will largely depend on the jurisdiction that issued the anti-arbitration injunction or the anti-suit injunction, and what are your links with that legal order? So assuming, for instance, that you are a British citizen and you have an anti-arbitration issued by an English court, I mean, the risk is contempt of court, and this is criminal, both and also civil, and so you would probably take it into account before going or not respecting that order. But if ever we go a step further, the arbitral tribunal, and Valeria, you might want to touch a word on this, does not have an obligation to follow the anti-arbitration injunction. Then again, the consideration that the tribunal will have for that measure will depend on where the seat of the arbitration is, where the arbitration is going to be enforced, and what were the grounds for granting the anti-arbitration agreement. And all these elements will come in balance when deciding whether to take them into account. If we go to the consequence of an award that's rendered without taking note of the anti-arbitration injunction, well, I mean, that will depend on where your arbitration was seated, but it will also depend on where you're trying to have your award recognized. And if we take the example of French courts, French courts do not consider that a party can decide to discontinue or not represent itself in an arbitration based on an anti-suit injunction. This would not be a ground for annulment, and it's not an excuse for them not to appear in the arbitration. So for French court, an anti-arbitration injunction will have no effect. They will literally look at whether the award is valid or whether it shouldn't be enforced based on the criteria of French law, taking no notice of the anti-arbitration measure. And just one last point is, again, if we look at French law will not recognize a foreign judgment if ever it was rendered disregarding an arbitration agreement. So let's take an example, especially now that England is no longer part of the EU, where an English court would consider that the arbitration agreement is not valid, and the arbitral tribunal was therefore not entitled or was not left to decide on whether it had jurisdiction or not. Well, that award would not be recognizable in France because it would be considered against French international public policy for the parties, or for the arbitration agreement of the parties, to be disregarded unless it was considered to be manifestly inexistent. So we don't have enough time to go more into the subject, but it's a very complex matter. And it's not because you obtain an anti-arbitration injunction in a country that your problem is solved. And most of the time, it may actually complexify matters unless everything can be kind of reduced to a single legal order. I don't know, Valeria, if you want to add anything to that.
Just a few things. The first one is answering to the question that you made. Indeed, arbitrators would, in principle, not be obliged to comply by any decision that is rendered by a foreign court ordering the suspension of the proceedings, or even the termination of the proceedings. And I think we have more than a couple of examples in case law in that sense. The problem would be if the arbitrators, for instance, are based in the same country in which the anti-arbitration injunction was granted. And we saw that, for instance, in cases here in Brazil. One that comes to my mind is the UEG Araucária, which was one very well-known case in early 2000, in which a state company was part of the proceedings. In Brazil, we were still discussing at that point whether or not state-owned companies could be submitted to arbitration. And there were a couple of court decisions that ordering the arbitration to be suspended. The seat of the arbitration was not in Brazil, if I'm not mistaken, was in France. And but the arbitrators were all actually based in Brazil, and because of that, they simply decided to comply with the order and to suspend the arbitration, because significant sanctions were being imposed not only upon the parties, but also upon the institution and the arbitral tribunal. So it will depend a lot on how aggressive the court order is and where the arbitrators are based and the other elements that you've mentioned. But in general, they are not necessarily forced to comply with that decision. I was involved in a case in Africa in which the court order said if the arbitrators did not comply with the anti-arbitration injunction, will be actually in jail for contempt of court. Obviously, that the conclusion that we arrived was that we would not be spending our next holidays in that African country, because obviously we did not want to risk to be in jail. But well, I mean, this is an anecdote that arbitrators sometimes have to face. I don't know if I can go there now, but I'll check that before having any ideas. In any case, this is how normally in international arbitration we address the issue, and the same works the other way around, meaning in anti-suit injunctions, it is also rare that a foreign court will necessarily abide by a decision that is rendered by an arbitral tribunal directly. What we see normally, obviously, in anti-suit injunctions is an order to the parties and not to the courts, which is a little bit different, to refrain from taking any actions against that arbitration. And if a party does not want to abide by that decision, it will not. So as you've mentioned, what maybe is the final solution for this kind of situation is what we know, the sanctions that can be imposed by the arbitrators in a final award, for instance, regarding costs, or even any other kind of sanctions that can be imposed depending on the law governing that arbitral proceedings. What comes to my mind is, for instance, something that is very well known to French practitioners, which is astreinte, and some civil law countries, they do also apply the same principle. So arbitrators could consider that. But again, that means that is an alternative solution to the anti-suit injunction. So I agree with you that it's not that simple, it's not that straightforward, and not necessarily the best solution for the situation.
Thank you very much, Thomas and Valeria. I thank you for adding new issues to our topic as well. Thomas not only talked about the anti-suit injunction, but also about the anti-arbitration injunction, which was quite good, and also a little bit of a battle of seats, which is also always and also interesting. So we are running a little bit of time, so I'll pass the word to Anthony, who will discuss and present his views about the worldwide freezing order. Anthony, is it a nuclear weapon?
Thank you, Andre. Yes, the worldwide freezing order was described by the English court in Bank Milat and Nikpur as the nuclear option in commercial litigation. And the purpose of my talk today is to talk about how the worldwide freezing order might be deployed to assist in international commercial arbitration. And it's a particularly powerful tool, I would suggest, when you're acting for a claimant against an evasive or possibly fraudulent respondent. If you can obtain a worldwide freezing order, it may bring about an early settlement, but even if it doesn't, it is likely to help you to secure the eventual enforcement of an award. So you might come away from my talk today thinking that if in those circumstances, a good strategy could be to freeze first and ask questions later. Now, I'm going to share some slides, and I'm just going to see if I can get that to work now. And I think with the wonders of modern technology, I am now sharing some slides in which I'm going to introduce to you the worldwide freezing order, what it does, who's bound by it, how you can obtain a worldwide freezing order in the English courts, and some issues about enforcement of awards. Now, I don't want to seem too parochial. It is the case that worldwide freezing orders can be obtained in other jurisdictions: the BVI, Cayman, Cyprus, Hong Kong, Singapore, Guernsey, Jersey, Bermuda, the Abu Dhabi global market, and the DIFC, sometimes with some restrictions. Of note, despite the economic significance of the United States, it does not offer a worldwide freezing order, as confirmed by the United States Supreme Court in Grupo Mexicano de Desarrollo and Alliance Bond Fund. Now, the English worldwide freezing order is particularly attractive, I'd suggest, because of global business activity touching upon London, the likelihood of respondents traveling through London, and because of the presence of essentially all globally significant banks or financial institutions in London. So that is why this is a particularly powerful weapon to be, if you can obtain it from the English courts. The worldwide freezing order is typically obtained ex parte without notice to the respondent, and usually it is accompanied by an asset disclosure order, and this measure only enhances the severity and the effectiveness of the remedy. The asset disclosure order obliges the respondent to disclose the location, value, and details of the entirety of their worldwide assets. Now, this is of interest because details of assets obtained at this stage may, with the leave of the court, be deployed later in the proceeding to aid in the enforcement of an eventual award. And I've provided an example on my slides of the National Bank Trust case in Europe, where that is what happened. The worldwide freezing order prevents the respondent from disposing of its assets wherever they may be located. It's not security. It's an order binding in personam on the respondent, however. The order can cover any type of assets, including assets held as trustee or nominee of a third party, assets in a company owned by the respondent, and also assets acquired during the course of the arbitration. So if there is an asset disclosure order in place, assets that come into the hands of the respondent during an arbitration will need to be disclosed. And then other than the respondent and its officers, if it's a company, third parties holding assets can also be obliged to comply with a worldwide freezing order. Now, a third party, such as a bank, is not going to be automatically bound by a worldwide freezing order if it's outside the jurisdiction of the English courts. But two things are relevant here. First, a bank which has a presence in the UK is even almost certainly going to comply voluntarily with a worldwide freezing order and not allow the respondent to deal with its assets. Or you can actually seek enforcement of the worldwide freezing order in another jurisdiction where that bank has a presence. The remedy is draconian. The consequences of breach are severe and can include fines. They can include debarring orders, preventing a respondent from presenting a defense on the case. For instance, a respondent can be arrested if he or she is traveling to the UK and in circumstances where it's in contempt of court, it's in breach of a worldwide freezing order. And there are cases where such persons have been imprisoned or ordered to be imprisoned, for instance, up to 22 months in the Blazov case, 24 months in the Thursfield case, and 21 months in the BTA Bank and Solochenko case I've listed on the slide. So if your respondent fails to comply with a worldwide freezing order, there is available to you the prospect of commencing contempt of court proceedings against the respondent with these types of very severe consequences. And even that step alone, the step of commencing or threatening to commence contempt proceedings, can in reality help facilitate settlement discussions. So looking at the conditions to be met, the position is clear with regard to English-seated arbitrations. The Arbitration Act 1996 gives the court the power, the same power as the English courts in commercial litigation, to grant injunctive relief of any type, including for the preservation of evidence or to grant interim injunctions of this type. With regard to non-English seated arbitrations, the English courts can and indeed do also grant worldwide freezing orders, although it is less common. The natural court for granting such relief would be the court at the seat of the arbitration. But Section 2, Paragraph 3 of the Arbitration Act expressly preserves this power to the English courts, even in the case of an arbitration with a foreign or undetermined seat. The court, though, will only grant a worldwide freezing order in respect of a non-English seated arbitration if there is a sufficient connection to England. And I'll give you an example of the ArcelorMittal and SL Steel case to illustrate this. This was a Minnesota-seated arbitration, and there were no significant assets of the respondent in England. However, there was evidence of business links to London, business activity touching upon London, and also evidence that the Minnesota court would not grant the same type of relief. And in those circumstances, the English court did step in and grant the worldwide freezing order. One thing to be clear, and we may come back to this, is that whilst the power exists to grant a worldwide freezing order in respect of a non-English seated arbitration and a respondent in a non-English seated arbitration, the English courts, of course, don't simply assert this extraterritorial power without consideration of whether the court would have jurisdiction and whether it's right to serve proceedings outside the jurisdiction. So those conditions must still be met. If you're seeking an injunction under Section 44 of the Arbitration Act, or you're seeking other orders that would affect or seek to enforce an arbitration award, the permission to serve proceedings out of the jurisdiction is given already in the CPR. but that is not always going to be sufficient. For instance, if we come to talk about freezing orders binding upon third parties, which is something we'll come to if we have time. Now, again, the courts are cognizant, of course, that there is an arbitral tribunal in place, or that there will be an arbitral tribunal in place, and so they are concerned not to transgress the powers of the tribunal. The worldwide freezing order will only be granted in situations of urgency, and also it will be necessary to show that the tribunal is not able to provide the same relief. Now, that will be the case where, for instance, the tribunal is not yet constituted, or there is evidence that the tribunal will not be able to move swiftly enough, or generally there is other evidence of great urgency. With regard to the generally applicable conditions to obtain a worldwide freezing order, the court must be satisfied that there are assets that could be attached in the foreign jurisdiction, that there is a good arguable case as to the merits, and where an arbitration is pending or it will be commenced, that would be simply to establish a prima facie case. Where we're talking about a freezing order after an arbitral award has been obtained successfully, this naturally would become moot. And there must be a real risk of dissipation of assets. This is a case-by-case, fact-specific inquiry, and typically the court will look to concrete, solid evidence of dishonesty or manipulation of corporate structures or evasiveness in order to be satisfied that there is a real risk of dissipation. Occasionally, or frequently, claimants will point to incorporation of shell companies and use of shell companies in tax havens, or the use of overly complex offshore structures. They'll also point to the respondent's credit record, all to try to establish that there is a real risk of dissipation. And I'll give you an example, maybe two here. Great Station Properties was a case involving a large London arbitration award, where the claimant then sought to enforce in Cyprus. And the English court was asked to grant a worldwide freezing order in that respect. And the court was persuaded by evidence that the respondent had used companies in his control in the past to avoid financial obligations and to divert assets, and also by evidence that the relevant companies didn't have shares. They had bearer certificates, which persuaded the court that there was a real risk of dissipation. The GML and Harfield case is a nice example to show how the respondent's evasiveness, its failure to comply with an asset disclosure order, helped persuade the court that there was a risk of dissipation of assets. And at the end of the day, it must be just and convenient to grant the order, which is shorthand for the English court's discretion to ensure that it is, in its view, meeting the justice of the particular circumstances at hand. Now, as I said, a worldwide freezing order is usually obtained on an ex parte basis, which means that the applicant must meet an obligation of full and frank disclosure. In other words, to draw to the court's attention all the relevant documents and all of the potential arguments that the respondent would draw to the court's attention if the respondent were participating. Given the seriousness of the order and the impact it has on a respondent, it's very often the case that an applicant will have to give a cross undertaking and to pay damages if the order is later found to have not been properly granted, or at least to pay and even to post some security in respect of that potential exposure. Now, as I said, when you talk about enforcing a worldwide freezing order, compliance is very often voluntary. Where enforcement is required, however, we need to look first at whether we are dealing with a London-seated arbitration and parties with a presence in London, or whether it's a foreign-seated arbitration. In a domestic scenario, non-compliance would be met by contempt proceedings, as I've already outlined. In a foreign-seated arbitration, the applicant who's obtained the worldwide freezing order must first seek the permission of the court to try to enforce the order abroad. Normally, they seek that permission at the outset when obtaining the worldwide freezing order, and then take that order to a foreign jurisdiction and seek to have it recognized in that jurisdiction. Now, my last point that I'll make is an interesting one, I think, and flows nicely onto the final talk that we will have today, which is to recognize, however, that some civil systems in particular may not recognize this worldwide freezing order, especially given that it's likely to have been obtained ex parte. Thank you very much.
Thank you very much, Anthony. This is a fascinating topic, and now I will give the floor to Fabiane, who has probably a really hard task to summarize all of these decisions that we are not very familiar as a Brazilian lawyers, and explain how we can enforce these decisions in Brazil, if we can. Fabiane.
Okay, thank you, Andre. First of all, I'd like to thank Canal Arbitragem and also Quinn Emanuel for a very kind invitation to share this panel with all of you. I'm very glad to be in this event. Thank you very much. Discussing such an amazing theme. It's very important, and also with very practical consequences for all of them who work with arbitration. So yes, as you mentioned, my task is not so easy. It's a little bit hard. And just to introduce this topic, I would like to mention that we have, in Brazil, we have a whole system of judiciary international cooperation. And this system is provided in our Code of Civil Procedure, also in the internal rules of Superior Court of Justice, which is the court competent to recognize foreign decisions, and also to grant exequatur to rogatory letters. And also we have also provisions on that in our constitution, especially granting this competence to this court, to Brazilian STJ. So, so we have, in some cases, we have the recognition of the foreign decision, and it can be on an arbitral award or a judgment. And in other cases, we have the granting of the exequatur of a rogatory letter, which we call carta rogatory. And usually the circumstances in which we will require a recognition are very, very established, and also the circumstances, the cases in which we should require a rogatory letter are also defined. But in some cases, we have a doubt about which tool should you use, right? And just to begin, I'd like to say that Brazilian law, our civil Code of Civil Procedure, establishes that in section 961, paragraph 1st, that we can only recognize a foreign decision when it is definitive, when it's the final one, right? And we also, this applies to judicial decisions, and in some cases also to arbitral awards. And also Brazilian STJ recognized in some decisions which were not rendered by a court, neither by an arbitral tribunal, but by some other authorities, just like, for example, the mayor of Tokyo and some, for example, religious tribunals. This kind of decisions are also recognized by Brazilian law. They were already recognized. We had a lot of case law about it, and now this provision states expressly in our civil code of civil procedure in paragraph 1, which says that even non-judicial decisions which have a judicial nature under Brazilian law, they should also be recognized, or they can also be subject to recognition. On the other hand, we have section 962 from our CPC, from our Code of Civil Procedure, which provides that we should use a rogatory letter when we need a measure with executory character. So paragraph 1st of article of section 962 provides that the execution or the foreclose in Brazil of a decision that's not final, a foreign decision that's not final, and that grants an interim measure should be granted, should be done through a rogatory letter, through quarta rogatória. So with this in mind, bearing all this in mind, and after all the amazing presentations of my colleagues, we should think about, so in these three kinds of decisions, the global freezing order, the anti-suit injunction, and the security for costs, what should we require for STJ? A recognition of the foreign decision or a rogatory letter, the granting of exequatur to a rogatory letter. So as I understood from my colleagues' presentations, both in cases of global freezing order and also securities for costs, in which we have interim measures, we should not require the recognition of such decisions. What we are going to request is a rogatory letter, right? And I'd like to mention something, some issues about it. Beginning from the end, from global freezing order, which Anthony Sinclair has just mentioned, and thank you for the lesson, Anthony. He said that, first of all, he said that the asset can be anyone. So usually, as far as I am concerned, the asset that we have in mind when we are talking about global freezing order is money, right? Money in a bank account, as I understood. But if, maybe, just to think about it, if the asset targeted by the party is, for example, a real estate, a movable property in Brazil, so if it's a land or apartment or something, it cannot be subject to, STJ will not provide this measure, because under Brazilian law, under our Code of Civil Procedure, section 23rd, Brazilian judges, Brazilian courts have exclusive jurisdiction over all lawsuits, over any disputes regarding real estate located in Brazil. So if, I don't know, but I think this is very rare, but if in case that the object of the global freezing order is an immovable property in Brazil, it cannot be granted this recognition or this letter rogatory, because it has to do with exclusive competence of Brazilian courts, and therefore it will not be granted, right? But talking about the more regular issues regarding global freezing order, in which you have more money to be targeted by the party, so we can divide this this question or this measure into two categories. So if this global freezing order is provided, is granted by a judicial court, by a court, either because the litigation, we have a litigation dispute before the judiciary, or because, for example, Anthony also mentioned, for example, we can ask a global freezing order to the judiciary, to the courts, because, for example, the arbitral tribunal was not constituted yet, right? So in this situation, we have a judicial decision, a judicial foreign decision granting a global or worldwide freezing order. So in this situation, what we're going to require is a rogatory letter, the consent, the granting of exequatur of a rogatory letter to STJ. And I have never seen this before, Anthony. I should confess, as Andre mentioned, it's very new for us. But maybe if the requisites are provided, and here in Brazil we are very liberal. We have a very pro-recognition case law, and so we have very few requisites like public policy and the competence authority. So if the STJ finds that these requisites were fulfilled, then I don't see any great problem regarding the rogatory letter, subject, of course, to each concrete case, right? But in this case, in the judicial order, in the judicial worldwide freezing order, then what we have to use is a rogatory letter. When this decision was granted or was rendered by a arbitral tribunal, then we have a little bit more difficult situation, because arbitral tribunals abroad, at least in principle, they cannot grant rogatory letters because they are not a judicial authority. We can think about some situations in which maybe the arbitral tribunal could, for example, request the local court of the seat of arbitration to grant to send a rogatory letter to STJ here in Brazil. But I don't know whether it's, we have to analyze local law, Lex 40, Lex, or that's the Lex of the seat of the arbitration, the law of the seat of arbitration, and also it's a little bit difficult because in many cases the arbitral tribunals is not composed of citizens of that country, right? So it's not so easy for the arbitral tribunal to request the local court to send a rogatory letter to STJ. So we have some doctrinal authorities that defend that the arbitral tribunal can issue a tool that we have in our law. I think Valeria has mentioned this. It's provided in Brazil Arbitration Act and also in our civil Code of Civil Procedure, which is the carta arbitral. So maybe arbitral letter, if you can nominate it like this. So and this arbitral letter, it's a very interesting and very useful tool that we have here in Brazil for the communication between the arbitral tribunal and the judiciary. So whenever the arbitral tribunal needs some help, some assessments, some help by Brazilian courts, by the court of the seat of the arbitration, it can request, it can send this arbitral letter to the court to try to have this measure, which the arbitral tribunal cannot have because it's not a judicial authority. So we have some doctrinal opinions that defend that in this case, in any case in which we have an arbitral tribunal with a seat in a foreign country, in a city in a foreign country, so an arbitral tribunal abroad, which requires some assistance from the judiciary. Some doctrinal authorities, like Andre Monteiro has a paper on that with some two other co-authors. So they defend in this article that the arbitral tribunal issues an arbitral letter directly to STJ. And this arbitral letter would have the same effects of a rogatory letter, right? So it's, I find this very interesting. I find this opinion very interesting. But as far as I know, we did not have so far any case which was granted an arbitral, the granting of an exequatur to an arbitral letter issued by a tribunal award sitting abroad. So, but maybe we can use this tool. And the same applies in principle to the security for costs. First of all, we have to think. I guess that Debora and David, they made a wonderful presentation on that. So congratulations to both of you guys. And they have already made this question: is it really necessary to try to recognize or enforce this in Brazil? In some cases, it's not actually necessary. But if we really think it's necessary, if we can conclude that it's really absolutely necessary to have this having effect, producing effects in Brazil, because recognition of a foreign decision, the objective of recognition of foreign decision in Brazil is to have the production of effects of this decision, right? And so when we talk about security for costs, actually what we also have is a measure, an interim measure. So as we said before, we cannot request the recognition of this measure, right? Because it's not final, and actually, at least in principle, the appropriate tool would be the rogatory letter, right? But the problem that we have is the same that we have just mentioned, because the arbitral tribunal, at least in principle, it cannot issue a rogatory letter to STJ, because it's not a judicial authority, right? The arbitral tribunal is not a court. So we have all these difficulties. But we can do what Andre defends and other authors also defend, that we use the arbitral letter. Arbitral tribunal will issue an arbitral letter directly to STJ. And I would like to mention, so although what we should technically use in this case would not be the recognition of an arbitral award, because it's not final, but we have one case, very interesting case, which is HDE 003671, rendered by STJ. Reporter was Minister João Otávio de Noronha, and it was published in our official gazette in December 3rd, 2019. In this case, it was a very interesting case. The parties are Albertor Capital, and well, the party that requiring parties Albertor Capital Limited. So in this case, there was an arbitration, and in this case, arbitral tribunal has granted 2 decisions regarding security for costs. And what they required was, what the party required was recognition of this decision, or alternatively, the granting of exequatur of these decisions, and that it should be accepted as a rogatory letter. And in this case, the STJ mentioned that it was not possible to actually recognize this decision because it was not final, but the request was granted on the grounds that it was STJ has accepted has accepted this request as a request for interim measure on the course of their recognition of the decision, of the arbitral award. So as we maybe have, if you have time, I don't know, but maybe if you have time, under Brazilian law, STJ can grant interim measures during the recognition proceeding. So it's expressly in law that they can do this. So they granted this decision on this ground, saying, well, if I cannot recognize these decisions on security for costs, the final award will be required to be recognized here. So what we are going to grant here is the interim measure. So we are going to recognize the security for costs on the grounds of an interim measure during the course of the recognition proceeding. So it's a very interesting case which I'd like to quote. So I know my time is almost up, and I would only like to refer to my last issue, which the anti-suit injunctions, and I'm going to say to devote some words only about to anti-suit injunctions and not anti-arbitration injunctions because I don't have time. But regarding anti-suit injunctions, it's a little bit easier. Our situation's a little bit easier before STJ. So we can divide this in two categories. So, for example, if a court, Thomas and Valeria have said a lot about it. Maybe sometimes in some situations we have a court providing for an anti-suit injunction. In some situations we have an arbitral tribunal granting this order. So whenever a court grants an anti-suit injunction, it's easier because there's no doubt that what we're going to require is a recognition of this decision, of this foreign decision, right? It's a final decision, and I don't see any problem regarding this. But if we have the arbitrator granting an arbitral award and anti-suit injunction, it's a little bit more difficult. We have two decisions that the arbitral award tribunal can grant. The first situation is in which he denies its competence and said, I'm not competent to do this, so to judge this dispute, so I don't grant this anti-suit injunction. This is easier because it's a final arbitral award, and I don't see any doubt about the possibility of recognizing this arbitral award. But if the arbitral award recognizes its competence, says, hey guys, I'm competent for that, and stops and sends an order for the court to stop the proceeding, is a little bit more difficult because it's not a final decision. But many doctrinal opinions are in which when the effects of this decision, which is not final, it's not has not to do only with that proceeding of that very arbitration, but has effects for the world, then in this situation, the recognition can be required. So we call it, whenever it has endoprocessual effects or inner proceeding effects, then it cannot be granted. But whenever it does not have endoprocessual effects or inner proceeding effects, when it does not have, which of course is the case, when the arbitrator recognizes its competence and says the court should stop its activity in a proceeding, then many authors, like Roberto Carmona, for example, defends that recognition can be required even if it's not final, as Section 961, paragraph 1st of Brazilian Code of Civil Procedure requires. So I'm here available for any questions that may arise, and thank you for the invitation once more.
Thank you very, very much, Fabiane. So we have 4 more minutes, and I think I have time for just one question. So maybe Anthony, so you mentioned that worldwide orders can be issued against third parties, and you mentioned banks, specifically banks. And I think it's worth exploring this possibility of orders against third parties a bit further. So, everyone here has already worked or seen, I mean, probably on a case where the respondent doesn't have a penny in his or her pocket, but a parent company, or maybe even the individuals that control the respondent, they have lots of money in their bank accounts, in the jurisdiction or outside the jurisdiction. The UK, right? England and Wales, to be precise. So in these sort of cases, would the English court grant a worldwide order against these entities, parent companies and the individuals that controls the respondent?
Andre, thank you for the question. My presentation was about the parties to an arbitration or an arbitration award. But now looking at third parties, yes, exceptionally, the English court will grant freezing orders against a non-party to an arbitration. The authority for this is a case called TSB Bank and Chabra, and these are sometimes called Chabra orders. And what you need to show is that there is a good reason to suppose that assets held by a third party would eventually be amenable to some enforcement measures to enforce your arbitral award or your judgment. And you mentioned banks, and the application to banks is a possibility, but probably more commonly, the jurisdiction arises where the third party is a trustee or a nominee holding assets, and in that circumstance, it is possible to get that order. And there are cases in England where that order has been granted in the context of an arbitration. There's a case, VAB Bank, it's a Russian bank against Maximov, where there was a London-seated LCIA arbitration, and the order was granted, a freezing order was granted in respect of the assets held by a trustee. Now, it's an exceptional remedy, and it should not oppress innocent third parties. It also does not transgress the basic rules of jurisdiction and service out of the jurisdiction. So when we're talking about a non-party to an arbitration who is outside the jurisdiction, we don't have that automatic permission to serve out of the jurisdiction that the CPR gives where you're seeking an injunction under Section 44 of the Arbitration Act. And so there are cases where a Chabra order was denied precisely for that basis. That the case I'm thinking of is called Cruz against Unitech, where the court said, yes, we in principle have the jurisdiction to grant a third-party order, a freezing order, but you still have to show that there is a presence in England or a gateway to serve that foreign party out of the jurisdiction. So short answer, yes, in exceptional cases. Thank you.
Okay, thank you very much, Anthony. Yeah, now it's much clearer for me what you were mentioning about, enforce the worldwide order against banks, and now with 30 parties, much clearer for me now. So it's we don't have much time. We don't have any other time for questions. So if you have questions to ask for each other, so please raise your hands. Otherwise, I will say thank you very much and thank you for your time. And hopefully, I will see all of you in person maybe next year, because I think this year. Oh, actually, I may go to the ICC Miami event in person, and I may find some of you there. So it's a possibility. Maybe this year we can see each other. So thank you very much. If everyone wants to say something else, so please say. Otherwise, thank you.